Hi everyone, welcome to the Oxford Policy Podcast. Today I'm pleased to be joined by Judge Mykola Gnatovskyy of the European Court of Human Rights. Before joining the court in June 2022, 4 months into Russia's full-scale invasion of Ukraine, he spent 6 years as president of the Council of Europe's Anti-Torture Committee, 20 years as an academic partner of the International Committee of the Red Cross, and taught international humanitarian law at the Taras Shevchenko National University in Kyiv. He arrived at a moment when the court had become the only international tribunal adjudicating human rights violations from Russia's war in Ukraine. Judge Gnatovskyy, thank you very much for being here.
Thank you very much for having me.
We're going to talk about what it means to be a judge in a time of war, and whether the legal architecture being built around Ukraine will reshape international justice. But first, for listeners who might not be familiar with the European Court of Human Rights, can you explain the context in which it was created, its evolution, and the role it plays today?
Well, thank you very much for this question, and I think it is essential to address it before we go into more complicated subjects. The court was created in the aftermath of the Second World War, and I think it is important, especially today, to understand this historical context. Because in fact, what was happening is that after the Second World War, especially in Europe, there was understanding that every effort should be made not to let it repeat itself, to avoid a large-scale war in Europe, understanding that with every new war, the number of victims, and primarily civilian victims, only grows. And essentially, there were 3 major tracks after the end of the Second World War on the legal front, so to say, to try and avoid future wars in Europe. One was to enshrine the general prohibition on the use of force in international law. It actually existed at the normative level before the Second World War. It was already present, albeit in a rather soft form, in the foundational documents of the League of Nations. And more clearly, it was already included into the 1928 Paris Agreement, the so-called Briand-Kellogg Pact. And of course, on its own, it did not prevent the Second World War. However, there was an attempt to do it and to include such a prohibition in the Charter of the United Nations. The second track was to ensure accountability for those who initiated the Second World War, and for those who committed major atrocities during the Second World War. It was done at least partially concerning Germany and also its allies in Asia, Japan, much less so in other contexts, and completely not concerning the victorious parties, such as the Soviet Union, which was initially, of course, Germany's accomplice in initiating the war of aggression in 1939. However, there was the Nuremberg trial that certainly laid the foundations for international criminal justice. And there were principles derived from that trial, which also sort of governed the international legal framework after that. And then the third strand was to ensure individual human rights. And the question arises why individual human rights should be seen as a means of preventing wars, armed conflicts. But in fact, the logic is, I think, very clear and very convincing. Those who initiate wars do not care about individuals and their rights. They do not care about individual human rights. For them, these are just figures and numbers of soldiers that they can deploy on the battlefield to achieve their political, geopolitical, or whatever kind of goals they have imagined themselves. They never care about the lives of people who are damaged, sometimes beyond repair, because of the war, people who are tortured, people who are raped, people whose belongings are destroyed, and so on and so forth. So to ensure the respect for individual human rights and to make sure that states actually place the individual in the center of their thinking was sort of the main project, or one of these main projects after the end of the Second World War. And at the universal level, this was done through the Universal Declaration of Human Rights in 1948. However, because it was universal and because it was a fairly novel thing, at the level of the United Nations, at the global level, this was not accompanied by any enforcement mechanisms. It was not accompanied by any body, international body, that could actually be addressed by persons who consider their rights under international law, human rights under international law, violated by the relevant states. And the declaration as such was not a legally binding document per se as such. However, in Europe, there was already readiness to go one step further, to have the same rights, essentially the same rights as in the Universal Declaration, but placed inside a legally binding treaty. The treaty is called the European Convention on Human Rights. Well, its official name was and still is the Convention for the Protection of Human Rights and Fundamental Freedoms. It was signed in Rome on the 4th of November 1950. And it was not just a legally binding convention, but also there was a mechanism created that would allow the right to an individual petition, individual application to the bodies created by the convention. Initially, these were the European Commission on Human Rights and the European Court of Human Rights. The European Commission of Human Rights was looking into the so-called admissibility of applications in sort of in a non-legal language that means whether the applications actually comply with the requirements set out in the convention, whether actually there is a case then for an international court such as the European Court of Human Rights to look into on substance, and then actually the court that was meant to be accessible and was meant to interpret the provisions of the European Convention on Human Rights. And it's also very important that this court is, whilst it is applying the convention, it is basically aware of the situation that is evolving in Europe. The societies may change their views. They may start recognizing sort of more substance to the rights that were enshrined in the convention initially, without changing the rights, but simply understanding that, in fact, in the modern day conditions, these rights mean something else. And there would be a court to say it, to apply the so-called doctrine of the living instrument. And with time, this court evolved a lot. The crucial moment, without going through all the many decades, over six decades of the actual operational existence of the court, I would say that probably the crucial moment was the fall of the Iron Curtain, basically the end of the Cold War, the disappearance of the Soviet Union and the states that were effectively, to a significant extent, controlled by the Soviet Union as an outcome of the Second World War, and them all joining the European community. But whilst the Western European countries went quite far on the road of economic integration to create European communities, and which later became the European Union, the new members of the European community, in the sense of the states of Central and Eastern Europe and the states that emerged after the fall of the Soviet Union, states that were occupied by the Soviet Union for half a century, like the three Baltic states, states that were also taken over by the communist Russia in early 1920s, such as Ukraine, for example. those states became independent, and they also wanted essentially to fully integrate with others. And in order to do that, the first thing you check essentially is whether these countries share the same values, have the same understanding exactly of the value of human rights and fundamental freedoms. So when those states joined the Council of Europe, which is the organization around which all this human rights infrastructure in Europe is built, not to be mixed with the EU. It's a pan-European organization, unlike the European Union. They also brought many more applications and much more work to the convention bodies, to the European Commission of Human Rights and European Court of Human Rights. And then there was a decision in late 1990s to reform that machinery, to instead of having the two bodies, to have just one permanent European Court of Human Rights, accessible for every individual, every human being, and also non-governmental organizations that claim violation of their rights under the European Convention on Human Rights, that very same 1950 convention, with respect to them. And the court became something more than it was before, I think, because it became really well integrated with the domestic judiciaries, in the sense that it was sort of looking into complicated human rights issues which were not resolved at the domestic level. So with time, this court became a unique international endeavor to protect human rights. And it's now an enormous legal, I would say, machine. Some people even say it's a legal factory, with 46 permanent judges, one elected in respect of each of the 46 member states of the Council of Europe, states parties to the European Convention on Human Rights, with 700 people working for the registry of the court, which is the permanent staff, the permanent secretariat of the court, which receives tens of thousands of applications every year. The court has already processed over 1,100,000 individual applications. So you can imagine it's something that is really truly accessible to Europeans, and as such, in my view, is a big value for it.
You're judge at a time when Ukraine is facing a full-scale invasion. Did this war change the day-to-day reality of the court? And as international judge, do you face more pressure because of the political states in this war?
I'll start from the end. I do not think I face much political pressure as an international judge because of the war. So in that respect, the red lines, the protection of the independence of judges of the European Court of Human Rights have not been crossed, and I cannot complain about having to withstand a lot of pressure on account of the war. However, of course, the 2022 full-scale invasion of Russia into Ukraine did change many things in the court, in the Council of Europe, and I think everywhere in Europe. And the court and the Council of Europe, they are not isolated, and they must not be isolated from the situation in Europe, from the perception that exists in Europe, of course, remaining fully independent and looking into the cases on their legal merits. The full-scale invasion of Russia into Ukraine led the Council of Europe to taking rather drastic action, basically resulting in a very swift expulsion of the Russian Federation from the Council of Europe. And the European Convention on Human Rights, which is the legal basis for the court, expressly requires states parties to the convention to be member states of the Council of Europe. So once Russia was expelled from the Council of Europe, under Article 58 of the convention, the 6 months period started to run, after which Russia also ceased to be a state party to the convention. So there was this half-year period which lasted until the 16th of September 2022, during which Russia was still was a state party to the convention, already without being member of the Council of Europe. And then, of course, for the court, it was very important to decide how to deal with various applications, with the thousands of applications filed with the court against Russia, including the interstate cases, the applications brought by Ukraine against Russia, the Netherlands against Russia, and also previously there were applications against Russia by Georgia. And newly emerging conflict-related cases, not only covering the period of the international armed conflict, the war between Russia and Ukraine, which started, as we all know, in 2014, with the occupation of Crimea and the beginning of the armed conflict in eastern regions of Ukraine. And the court had to understand how to proceed with these cases. The court prioritized the examination of interstate cases. The court also categorized the remaining cases against Russia into different groups and chose the approach that, in its view, was the most appropriate for each of those groups. And it had to fulfill its judicial function. So it did, and so did I, in my capacity as a judge of the court, also as a judge elected in respect of Ukraine. Of course, I was involved in and remain involved in deciding the interstate applications brought by Ukraine against Russia.
You mentioned the interstate application. I think we will have time after to talk about the Grand Chamber ruling, Ukraine and Netherlands versus Russia. But first, because you talked about the expulsion of Russia from the Council of Europe and that Russia ceased to be a party at the convention, can the court still take Russia's accountable since Russia has left the system?
The court must act in accordance with the convention. There is no other option. The convention is very clear. The temporal jurisdiction lasts and covers the events happening until the last day of Russia's membership in Russia's participation in the European Convention on Human Rights, which is, as I said, the 16th of September 2022. So the court remains competent to deal with cases that arise from the events until the 16th of September 2022. There could be also lasting situations which started before that date, and some of them would also fall under the jurisdiction of the court, and not concerning the events happening after that date. The court had to deal with these cases, and it has to complete its function in dealing with these cases because it has the jurisdiction and it has the duty. This is what the convention requires it to do, and this is what it does. And there are good reasons beyond the formal compliance with the convention to continue doing this.
But don't you think that it can weaken the credibility of the court if the rulings are only on the paper, but Russia is not falling under any enforcement prospects from the court?
Well, the court cannot speculate about the enforcement prospects. What the court can and actually should do is precisely to exercise its function under the convention. Because people who filed the applications, they wait for the answer from the court. They want to have at least the decision of the court that would legally qualify what they went through, that would acknowledge, if there is, of course, the sufficient basis for it, Russia's legal responsibility for violations of human rights, and judgments that would also create the historical record, that would actually place all these evidence in the right order. It will be scrupulously examined by the court in every case, and it will give them at least something. Of course, the question of the implementation of these judgments is a very important one. In principle, the European Convention on Human Rights separates the powers. Like within a state, there is a separation between legislative power, the executive power, and the judicial power. Then, in the convention system, there is a separation between the court that has to decide on cases and the Committee of Ministers of the Council of Europe that deals with the supervision of how these cases are actually implemented, or as the convention uses the word, executed. So the execution, the implementation of these judgments is something that inevitably will be a political question for now, for the future, but the legal assessment will be done by the court. And I think that in itself is extremely important for us, as long as we still maintain hope that Europe will once again become a peaceful continent which is governed by the rule of law.
Okay. Now on the interstate application, in July 2025, the Grand Chamber delivered a judgment Ukraine and Netherlands against versus Russia, nearly 500 pages spanning 4 interstate applications from 2014 to 2022. The court itself called it one of the most consequential judgments in its history. Can you walk us through what this case was about and why is it so important?
Well, first of all, I would agree with this assessment. I think it was done by the court registrar, exactly, and I think Madame Civili, she's absolutely correct. I fully share this assessment. It is one of the most consequential judgments, and it is one of the most important cases in the history of the court. And the reason why I think so, it has a lot to do with what we started with today, basically when and why the court was created. The court was created as a part of the strategy to maintain peace in Europe. Peace that is based on human rights, democracy, and the rule of law. And the Russia's aggression against Ukraine, which, as the court also explains in the judgment on merits in the case of Ukraine and the Netherlands versus Russia, the one that you referred to, of July 2025, it was not, and it is not only limited to the direct armed attack of Ukraine, but also with a broader effort to undermine peace and democracy and rule of law in Europe, accompanied with a lot of aggressive statements and factual aggressive behavior concerning other European states other than Ukraine. So essentially challenging the very foundations of the legal order that exists in Europe. So it was, for the court, it was very important to say that the court is aware of this context, that the court remembers very well why it was created and what is the overarching idea behind the convention that deals with individual human rights and protects democracy and rule of law. So in that respect, I think that this is a crucial judgment. Indeed, the main text is 500 pages. There are also thousands of pages of annexes because there's a lot of evidentiary basis for this judgment. The case started, as you said correctly, with applications, interstate applications lodged by Ukraine with the court back in 2014. And this is not the only, of course, interstate case that the court has had to examine between Ukraine and Russia. In 2024, the court delivered its Grand Chamber judgment in the case Ukraine versus Russia concerning Crimea. There are two more interstate cases in the docket of the court. One deals with a naval incident of 2018 in the Kerch Strait, whereas the remaining one deals with the allegations of political assassinations abroad of the political enemies of the Russian government. But the case of Ukraine and the Netherlands versus Russia is, of course, the biggest case because it covers the several different aspects which are all united in the same context, I would say, and which are inextricably, I would say, connected. So the first aspect concerns armed activities in eastern regions of Ukraine in 2014, 2015, and in further years, where Russia denied its involvement and instead pretended that these events were solely happening between Ukraine and the so-called separatist entities, the so-called Donetsk and Lugansk People's Republics. During that very initial period, the episode that also made the entire world shudder was the downing of the Malaysian Airlines flight MH17 in the Ukrainian airspace over the Donetsk region. And Ukraine did include this episode in its complaints, which, of course, comprise many other episodes as well. But this particular episode was the subject of the interstate application filed by the Netherlands against Russia, and the court joined it to the Ukrainian application because it concerned the same events. And then, of course, when the court was already examining this case and when the court held public hearing about the admissibility of that case in the Grand Chamber in January 2022, already the atmosphere was extremely tense and everyone was concerned that Russia might actually attack Ukraine at a much broader scale. Which happened the next month, and Ukraine filed another interstate application. It was the 10th interstate application filed by Ukraine against Russia that concerned precisely the events of 2022. And in 2023, after already having delivered the admissibility decision in the case of Ukraine and the Netherlands versus Russia concerning eastern Ukraine, the Grand Chamber decided to join the complaint about the full-scale invasion of 2022 to that initial case, not to lose any time, basically, and also being mindful of the fact that this is essentially the continuation of the previous events. So the case concerns everything that started in February 2014 until the moment when Russia ceased to be party to the European Convention on Human Rights in September 2022. The case is important at so many different levels, but as I said, for me, the crucial thing is the understanding and the fact that the court underlines how much these events are harmful to the very idea why the convention was created, to the maintenance of peace in Europe. And then the court analyzes the attribution of the acts of the so-called separatist entities, whether actually Russia is responsible for them, and gives the affirmative answer in that respect. Then the court also clarifies its approach to jurisdiction in this kind of cases. That might sound like a very complicated legal discussion, but essentially the question is to answer is the following: when a state is responsible for the observance of human rights beyond its borders, abroad. Because as a rule, these obligations are territorial. They are limited to confined to the territory of the state. But when it attacks another state, is it responsible also for the consequences of that attack on human rights? And this is not a simple question, and the court answered it differently concerning different events, different armed conflicts, and different episodes, and also considering the concrete acts that were alleged. But in this case, the court came to the conclusion that everything that Russia was doing from 2014 was essentially the part of the same campaign. It was all logical, organized, and then, of course, the full-scale invasion that clearly pursued the purpose of destroying Ukraine as an independent state, that attained such a level of organization that, of course, there is accountability. There must be accountability of Russia for all the acts that concern this war, including, for example, even let's say bombing and launching missiles to parts of the territory of Ukraine which Russia never physically controlled. And then the case meticulously goes through the tens of thousands of pages of evidence collected by independent international investigative mechanisms, such as the fact-finding commission created by the Office of the High Commissioner of the United Nations, by the Human Rights Council of the United Nations, such as the investigative mechanisms created by the OSCE, the Organization for Security and Cooperation in Europe, the credible reports of various independent international organizations. They are all assessed basically against each other, and their consistency is verified. And then the court puts on record systemic practices, the so-called administrative practices, which is basically systemic state-run campaigns of violation of human rights, and there is the whole catalog of such violations, starting from the right to life, the prohibition of torture, and ending with the let's say with the right to education and the prohibition of discrimination. So in that respect, this is the only, so far, fully fledged judgment of a competent international court concerning the events of the war. And in that respect, I think you cannot possibly overestimate the importance of this judgment.
Alongside this very important judgment, there is the creation of the Special Tribunal for the crime of aggression against Ukraine that was very recently created. Can you explain us a bit what is this Special Tribunal and why was it needed alongside existing institutions such as the ECHR, but also the ICC?
Yes, thank you very much for this question. The project of the Special Tribunal for the crime of aggression against Ukraine is very close to my heart because, and there is no reason for me to hide it, I was involved in actually designing this project at the very outset. Before I was elected as judge at the European Court of Human Rights. Of course, once I was elected, which happened in late April 22, and I started, as you mentioned, my judicial office in June 22. Then I, of course, had to immediately distance myself from this kind of initiatives, but simply because I have another job and I deal with another type of cases. But it was obvious for those who came up with this idea, and this was, I think, it's quite easy actually to name the author of the idea. It's a very well-known British-French lawyer, professor of international law, and an excellent publicist as well, Philip Sands. And then there was a group of people who supported him in designing this project in the first place before it was taken over by the governments. And I was lucky enough to be there alongside Professor Dapo Akandi, who was at that time at the Blavatnik School in Oxford, who is now the Chichely Professor of Public International Law in Oxford, and Philip Leach, another eminent English UK professor of human rights law, and a number of other colleagues. We, within 1 week's time, we basically convened a conference or an online event hosted by Chatham House to issue a statement and a declaration calling for the creation of such a tribunal. And then, of course, states took this over, and then it became already their business how they actually did it. But the idea from the outset was very clear. The special tribunal is needed because there is a glaring institutional gap in the architecture of international justice. The European Court of Human Rights deals with individual human rights violations, even if they occur at the large scale, even if they have the systemic nature. Still, it's confined. Its remit is confined to judging whether a state has complied with its obligations to respect human rights under the European Convention on Human Rights. Now, the International Criminal Court would be a perfect international body to deal with the crime of aggression. Had it in its disposal the necessary legal tools, and unfortunately it doesn't have those tools, because the crime of aggression, it's very long, and I would say, to my mind, it's a very sad story of how states where many influential states were reluctant to vest the ICC with the jurisdiction to deal with the crime of aggression. But the bottom line is that whilst theoretically it has this jurisdiction, in practice it cannot and absolutely cannot exercise it concerning states which are not parties to the Rome Statute of the International Criminal Court and to the Kampala amendments of the Rome Statute of the ICC. And the Russian Federation is not a member, not state party to the ICC, and even more so, of course, to the Kampala amendments. Ukraine, at the time of the full-scale invasion, Ukraine already for some time accepted the jurisdiction of the ICC. It then ratified the Rome Statute and the Kampala amendments, but it's still impossible for the ICC to deal with this case against Russian suspects. Now, as regards the Special Tribunal, the need to create it was because the prohibition of aggression in international law is clear. The crime of aggression is also recognized, but there was nobody that could actually pursue those cases. And for, I think, for the world, and of course for Ukraine, and for Europe in the sense of the Council of Europe's Europe, which includes the United Kingdom, which includes many states which are not member states of the European Union. It's once again it's a separate organization. It's crucially important to support this initiative, and that's why I think it has been supported, precisely because the impunity for the crime of aggression would completely undermine the very basics of our hope to have Europe which is peaceful, free, and economically prosperous. And in that respect, once again, I'm coming back to where I started. It's the part of the same formula to maintain peace in Europe, to have protection of human rights through the European Court of Human Rights, but also to have accountability of those who create the most egregious crimes against international law, against peace and security and human rights and so on. So these are all very connected things. The European Court of Human Rights is a totally separate thing. It cannot possibly look into questions of war and peace and aggression and so on, but it does its job, so the Special Tribunal must do its job.
And now that the Special Tribunal has been agreed and funded, and that there is a task force, what are the main obstacles for it to be operational?
Well, I can only judge about this as an external observer. I'm not privy to the actual discussions around it. From what we can see, what is publicly available from the Council of Europe, which is the main institutional sponsor of the creation of the Special Tribunal, currently there is a sort of process of states ratifying the so-called partial agreement on the creation of the Special Tribunal. So gradually they will do that. Ratifying a treaty is not so easy because it generally requires preparation. It requires also decision of the national parliament and so forth. So there should be this critical number of countries which agree to be part of the tribunal. At the institutional level, within the Council of Europe, there's a lot of votes, and there's a lot of the vast majority of Council of Europe member states are in, and there are also non-European states which participate in this project. But then this should materialize. Then, of course, it should be properly funded because, as I understand from the public information, what has been funded so far is just the initial steps, the sort of the advanced team, so to say, and there should be also a way of having the stable institution. I personally do not think that it should be a bulky institution. I do not think that it should be in any way expensive institution, but its existence is crucially important, and it does justify the investment. I once had this discussion with one of the eminent professors of international criminal law, who was extremely skeptical about the Special Tribunal. And as any initiative which is new, you can always find ways of criticizing it. It's absolutely fine and not particularly intellectually challenging, I would say. And as one of the arguments, they put forward the argument of the cost, saying, well, you will have to pay the number of people, there's at least a permanent registry of the court and the premises and so on, and why should we invest the money and so forth. And I must say I was quite upset about this line of argument, and I said, perhaps a little bit emotionally, that, well, of course, if you calculate the cost of international justice in pounds, dollars, euros, that might sound like a fairly expensive enterprise. But try calculating it in ballistic missiles, for example. You will see that it costs literally nothing.
Okay. So we talked about jurisdiction, about the process of accountability, but I want to ask you, what does fair justice really look like for Ukrainians? Because the people of Ukraine have suffered immensely over the past 4 years and even more, with thousands of deaths, casualties, entire cities destroyed, children taken away from their families. So, what does justice look like for the people of Ukraine?
It's not easy to answer. I think, like for any victims of serious crimes, the starting point is the recognition of the crime, the recognition of the suffering that you have just mentioned, the understanding that there is a clear assessment of what has happened. Ideally, a judicial ruling, which is also in itself achieved by means of a fair trial, complying with the best standards of sort of due process of law. And the understanding that these crimes are not going to be forgotten, that there won't be somebody coming, well, now let's just forget about all the suffering, let's just amnesty all the criminals, all the perpetrators of crimes against humanity and war crimes and the crime of aggression, because we want a deal with them and we want to return to business as usual. So I think for Ukrainians it is important that this doesn't happen, because peace will not persist without justice. To my mind, many of the issues that we face now in the world have their origins, among other things, in the failures of justice for the previous occasions of major violations of peace, of major atrocities. So the best investment into lasting peace is justice.
Okay, we drove around this during the whole episode, but as a closing last question, do you think this war is fundamentally reshaping human rights in the world and European human rights?
Well, I think it will reshape, and it is reshaping to a significant extent our awareness of the importance of human rights, our understanding how the institutions should be functioning. I don't think that human rights as such will change because of this war. It's rather how we manage to vindicate those human rights, how we manage to protect them, how we manage to ensure that there will be no impunity. Otherwise, I think that the lessons of and the achievements of the last 75 years or more, precisely the time during which the European Convention on Human Rights is in operation, will not be erased. It won't be possible, and to simply forget about those things, because those who start wars, those who commit those crimes, and those who think that, well, there's nothing special in this kind of events, they actually would very much like to erase those rights. They would very much like to basically pretend, well, this is just some sort of irrelevant thing, and it's all this discussion about human rights, all these efforts made over the decades, this is just hot air, there is nothing. Now we must actually make sure that they do not succeed also in this, because human rights, for example, in Europe, and I will say thanks to the European Court of Human Rights, fundamentally changed European societies. A lot of different things across Europe have improved for people thanks to the European Convention on Human Rights and the judgments of the European Court of Human Rights. And when we are back to square one, in the sense that we are back to the situation of war, we are back to the situation which is very similar, unfortunately, to what we were faced with 75 or 80 years ago. We must not begin from a clean sheet, from scratch. So in that respect, I think human rights will persevere, and the relevant mechanisms as well.
Judge Gnatovskyy, thank you very much for these insights about international justice, for your time here in Oxford. Thanks everyone for watching these episodes. Don't forget to subscribe, and we hope many more episodes to come.
Thank you very much.
Thank you.